Okay, welcome back to another episode of the 526 podcast with Bruisa and Friends. Today we got a legal rock star joining us today. Justin, this civil litigation attorney who crushed his studies at Cooley Law School. He graduated at top of his classes at not one but both campuses. Justin, that's pretty impressive. Welcome to the show, my friend.
Thank you for
Uh,
having me.
Okay, before we get started, let's talk about law school. So, at what point did you know that you wanted to become a lawyer, and what drew you to Cooley Law School versus the other law schools?
So I guess it's a complicated question. My dad was actually a police officer, so that's kind of how I got involved with the law. I was always good at school. I was a good writer, which is probably one of the most important traits to actually be a lawyer. I went to college at the University of West Florida. That's up in the Panhandle. I graduated in 3 years. I was pre-law. Then I got my master's. I kind of hung out for 2 years.
Okay.
And then at that point, I was finally ready for law school, and I got a good scholarship to go to Cooley, which has a campus in Tampa. When I was in law school, there was 3 campuses in Michigan, and then they had the one down here in Tampa. And this was a good location. Got a good scholarship, so that's kind of how I wound up here.
Oh, okay. That's good. So let's go ahead. Let's talk about the LSAT. So, what was your preparation like for the LSAT? Like, I know that it's a notoriously rough test. It's high. It's ranked up there with amongst all the other aptitude tests. But how did you prepare for it? And did you have any specific strategies on how you approached it?
So the LSAT or the bar?
The LSAT.
LSAT. Okay. So the law school admissions test, which is the LSAT, is the test that you have to take in order to go to law school.
Yeah.
Pretty much like every law school will require 2 things. They'll require a bachelor's degree, and then they'll require taking the law school admissions test. And most schools will take your score into account. The best way to do well on the LSAT is to take an LSAT prep course. So
Hmm.
that's something that I would recommend that everyone does. And I actually give a plug to a friend of mine that I went to law school with. His family actually owns an LSAT prep company in Tampa. It's called Blackstone. So
Ah.
if you want to do well on the LSAT, take an LSAT prep course, take Blackstone, or take even a competitor. So like Kaplan has an LSAT prep course. It's one of the big companies that does all the prep courses. They're worth every penny. The law school admission test is incredibly challenging. It's it's more challenging than the bar in the sense that the timer is always going. So like the sections, this is a long time ago since I've taken it, but I think the sections are like 25 minutes and it's just like go, 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 go. It's not like the bar where you have like a 3 hour section, then you have a break, another 3 hour section. It's just,
Mm.
okay, here's this, here's this, here's this. And then when you're prepping for, let's say, the bar, you kind of have like the ideas. It's like, what do you have to know? You have to know the law. With the LSAT, it's more of teaching you like how are you thinking. So, for instance, like there's a logic game section. It's the section that everybody hates, and
Mm.
it's just like everything is practice, practice, practice. So logic game is not a fun section. Then let's see the other sections. There's the reading section, and then there's a couple of critical thinking sections, and it's just like everything. It's something that you do the prep course, and then you just practice, 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 and that's the best advice that I could give anyone. You don't want to go to the LSAT test like the first time and
Hmm.
not have like the practice, not know what it feels like to actually do a portion of the test, because that clock, that 25 minutes, it just goes by so fast.
Now, when you say practice, 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 now is there any time frame like how that individuals should study? I've talked to a couple of people before. I've heard people say they studied anywhere from months. It just depends on the
Yeah,
average person. How long did it take for you to study? How many months?
probably 2 months. The
Okay.
bar is more like a 4 month prep. I think you can get away with 2 to 3 months for the LSAT, but it's
Wow.
just like everything. Like the longer you do it, forget how long the LSAT prep tests are, but see what the LSAT prep companies are doing, and then do the course, and then just follow the instructions on the course, and don't get distracted. I think a lot of people like take like a bar prep course or an LSAT prep course, and they just don't maximize the prep. They think like, okay, well, I paid for this, I did the bare minimum, or I want days off. It's no, no, you follow it to a T, and they'll give you like daily things to do, and you just make sure you do them, and that's how you're constantly like keeping up with it. And that way, when you finally get to test day, you've had several practice tests. You're constantly being under like the same conditions as if you were taking the test, and that's how you ensure that you get a good score.
And what's the time limit on that?
I think it's 25 minutes a section. I don't know if it's changed since I took it. Man, I probably took it in 2012. So it's
Oh
big
wow,
for me.
yeah, that is a long time ago.
Yeah, I probably took it in 2012.
Yeah, that's a long time. Okay, so that's great advice. Now let's talk about Cooley Law School itself. I hear it has a fantastic reputation. So, what was your reputation like there? What was a typical day for you?
I
I
mean,
know that I know you
yeah,
told me. I'm sorry. I know you told me earlier that you didn't you finished. You took less time than most people. You didn't take the full time to
yeah.
graduate.
So traditionally, law school is 3 years, right?
Hmm.
And what if you go to like a law school, you take a fall semester and then you take a spring semester, and that's it. And typically, like during the summer, what you're doing is you're working in the legal profession. Either
Hmm.
you're interning or you're working for a judge or you're clerking. You're doing something like that. For me, it's something that's advantageous at Cooley is they, at least when I was going there, they had classes all year round. And then, so there were a lot of students that were taking part-time and just going the full. So instead of taking, let's say 15 credits a semester, like you would do at a regular law school, there's a lot of students that were taking 12 or 9, 3 classes, 4 classes. For me, I did what they called the suicide tract. And with the
Wow.
suicide tract is you're condensing 3 years of law school into 2. And so how do you do that? You take full time during the summer. So it's 15
Okay.
credits every semester, including the summer. And that allowed me to graduate in 2 years as opposed to the full 3 years. So I actually graduated at the end of summer, which is something that's a little bit of a drawback. So graduation at Cooley for the summer class, that's in September. The bar is offered two times a year in Florida. It's offered in, let's see, July and February. So because I graduated in September, I had missed the July bar, right? Because you
Okay.
have to graduate before you can take the bar. So I
Hmm.
had to wait 6 months before I could take the February bar. And for me, I used that as working at a law firm. So I worked at a law firm a couple more months, and then I was able to do the full time. I took, I think I took Kaplan for bar prep. Yeah, I took Kaplan. I was able to do that for, I'm pretty sure it was 2 or 3 months, where that's all I did was the prep course. But yeah, that was
Wow.
the big advantage, is that I was able to speed through the process. Instead of it taking me 3 years, I was able to do it in 2.
Okay, is that something that you would recommend most law students doing, or would you recommend most law students sticking with the traditional three, or it just
It,
depends?
it very much depends on your own like individual schedule. If you can do it in 2, I highly recommend doing that. However, if you're working full time, you have kids, then the 2-year track probably isn't the best for you. I didn't have kids, so I was able to do it. A lot of my peers at Cooley did have kids, they had jobs, and these were things that forced them to go to school like more part time. But for me, I had a select group of friends. All of us were more or less on the suicide track, and it was just the at least 3 of us made it, like from start to finish, just doing the full time all year round, and it was a lot. But yeah, if you can do it in 2, it saves you time, because the faster you go through everything, the faster you get your license, the faster you can actually be a lawyer.
Okay, now traditionally law school is traditionally so much different from any other university because obviously you're learning the law. But what advice, or do you have any advice to any current law students or that's in law school or actually want to pursue law?
Yeah, I mean, a lot of it is, get away from TV, because
Hmm.
everything you see on TV, it's not real. I'm a civil litigator. I handle like all aspects of litigation, and I have not, it's kind of embarrassing, but I haven't been in, even though I do civil litigation full time, like everything is remote nowadays. So I have
Hmm.
not physically been in a courtroom since before the pandemic. Every when I take a deposition, it's just like this. It's just a conversation with me. Let's say you're the person I'm deposing. We'd have a
Hmm.
court reporter there. We'd have another lawyer, but it's all over video, just like this. Even hearings, right? So I could
So
have a hearing in state court. It's typically going to be over video like this, and that can get messy. But it's not like you go into court and there's this profound thing that happens, and then you win, and then everyone celebrates. That's not typically like how the practice of law is. And in real
okay,
life, especially with civil litigation. Even though you're expecting everything to go to trial, most things don't go to trial. And so you're really just structuring things and moving it to a point where it's like, okay, guys, we can resolve this informally. And that's typically like what we're looking for is, resolve things informally when we can. And it's not, I'm going to depose the 10. You typically get 10, and in federal court, you get 10 depositions. I'm not deposing 10 people in, every single one of my federal cases. It's just not going to happen.
Okay.
So, like most of your day is really spent, in an office on a computer, doing discovery. You'll hear that in law school, that most of civil litigation is just being in the discovery phase. And that's true. But it's not, you go to court every day and you have like this big celebration. That's not what a practice of law is. It's something where, you can get everyone together and see if you can get them to agree. And that's really what it is. It's not, we're going to go argue every little thing before a judge.
Right. Just come to some type of mutual understanding. So how did law school experience prepare you or not prepare you for the realities of litigation?
Yeah. So, I mean, when you're going to law school, you're learning like general aspects of the law. Like, okay, what is a claim? What are the elements of a claim? Procedural, like how does civil procedure work? How does evidence work? They're teaching you how to think like a lawyer. They're not teaching you for like the nitty gritty. And everything in law school is very ideal, where it's like, okay, this is what a motion for summary judgment is, for instance, which is a case that if you have a motion for summary judgment granted, that can decide your case on the merits without having to go before a jury or take an evidentiary hearing or anything like that. And those aren't things that are really taught in law school. Like they don't teach you in law school, like this is how you write a motion. This is how you take a deposition. I mean, I remember like the first time I took a deposition as a first year lawyer, I'd never been to a deposition. I'd never taken one. I just, some kid coming with a large stack of papers at a court reporter's office. It's not something that they teach you in law school.
Okay.
Cooley actually does have a small amount of classes on that, which is more than like most law schools will have. But it really takes time. I mean, a lot of it's like, for instance, like if you take a trial class in law school, like, law schools offer trial classes. You'll have, a full trial and, you can do like a trial competition. The trial competition will last maybe 2 hours. I took a deposition a few weeks ago. It's 5 hours. I remember thinking in law school, like, oh, 15 minutes a question, like that's so much, but it's not. Now it's like, oh man, I have so much stuff. Like, how can I get this condensed into like a reasonable amount of time where I'm not going to spend 10 hours here. I'm hopeful I can get it done in 5 because, I don't, I'm billing my clients hourly. I don't want to take up like everyone else's time. But on the other hand, like there's a lot of stuff. Like the universe of stuff is so much bigger than what they show you in law school. Because in law school, you're just, you're either on time constraints or you're reading orders. Like most of what you're doing in law school is reading, let's say constitutional law orders, things that the Supreme Court comes up with. There's not really a lot of discussion of like the nitty gritty stuff to get you to that point. And that was something that was totally new to me because, when you're a lawyer, you're dealing with the nitty gritty stuff. Like what are the actual facts of the case? How are they good? How are they bad? Like the facts are so much more important than, these orders that you're reading in law school.
Okay. I was going to ask you about that. Being the fact that you obviously work for an actual attorney office. So do you get to pick your cases, or what factors do you consider when you take upon your civil litigation cases? Do you look at your bosses and say, hey, I'm not sure about this one?
Sorry, I lost you for a second. Let me
Oh, it's okay.
Yeah. There you go. Okay, so it depends, right? So if you are, let's say you have like your own law firm, you can pick and choose like whatever you want. When you're working at like a large defense firm like I am, you're actually working with the same corporate clients. And so, you'll just get an email from a client and it'll be like, okay, here's your new case. And
Okay.
we would run a conflict check to make sure we don't have any conflicts. And then bam, Justin has a new case. And that's literally the process. It's something where, if you're on the defense side, like I am, and you're working for like large companies, they're going to send you work. Like there's no, you don't have to worry like, oh, I'm not going to have enough cases. Like now you're going to have enough cases.
Right.
But yeah, it's just I'm working with the same corporate clients like every time, and I get to know like the faces behind the corporate clients, and they're sending me work, and I would literally sometimes you get a phone call, and most of the time it's done through email. And just get an email. It's like, bam, you have a new case. Sometimes you get a couple cases a day, and you're like, oh man, I'm never gonna have time for this.
Okay, well, dealing with so many clients, it has to be tough dealing with so many personalities and emotions. So, like, how do you build that trust and manage expectations with your clients?
Yeah, so if again, this is something where it's nice when you're working at a big law firm because it's very structured.
Mm-hmm.
So the older lawyers who are more experienced, they'll be the ones doing like the speaking to the client, and you'll just be like this CC on an email, and then that'll be it. Like your first year, there's not going to be a lot of like talking to like my corporate client. It's just going to be they're going to see my name out there, right? And then you'll slowly be tossed like bigger and bigger stuff, and then eventually you're meeting these people for dinner, and then you're going to a mediation and meeting them in person for the first time. It takes years to build that sort of trust. I've been representing the same people for my entire career now, which is I'm going on 7 years.
Oh, wow.
And in this, it's I've been representing the same 5 or 6 corporate clients that I've just been doing forever. It just takes a long time to build that trust. It doesn't happen overnight. It's something that gradually happens. You go from just being a CC to explaining to the client what's going on, and then you'll write your clients letters explaining to them like, okay, here's what's happening, and they'll see your signature at the bottom, and then eventually like they'll start getting to know you. I mean, eventually, that it becomes funny because when you work with other lawyers, they just send everything to you because they know you, right? And
Mm-hmm.
it's like that's actually not my case. That's someone else I work with, but they know you. Like you're the face that they deal with, which is
Oh,
starting to happen more and more. Like the longer I do this, like they just look for me because I've been doing this for so long.
so long. Okay, let's talk discovery and pre-trial strategy. Can you walk me through a typical discovery process in a civil case?
Yeah, I mean, the discovery doesn't happen when the case happens.
Okay,
Hopefully,
right.
most of when you're doing like what I'm doing, like you wouldn't think like how early lawyers can be involved, but I can be involved with something like years before, like just helping out with the investigation before things actually go to any sort of litigation. But litigating in state court versus federal court is something that's entirely different. If you're talking about like formal discovery, in Florida, when a lawsuit is filed, as soon as the defendant is served, the discovery process starts. Like the gun already starts. Like when can you start serving interrogatories in state court? Like immediately. In federal court, it's a little bit different. In federal court, after the lawsuit commences, which in my cases, I'm removing cases to federal court. You can't conduct any sort of discovery in federal court until you do what's called Rule 26.
Mm-hmm.
Which is basically like, okay, here's the non-privileged stuff I have. Give me the non-privileged stuff you have. That way, there's free exchange of information in federal court. You're ordered to do that. In state court, you don't have that. And in state court, it's more of like, okay, what can I keep from the other side? Like, let me just answer what they're asking for. There's more I can withhold in state court than in federal court. But on the other hand, the federal court process is a lot more streamlined. Like as soon as you conduct Rule 26 in federal court, then you're automatically going to be placed on a scheduling order. And in federal court, they don't like to change the scheduling order. And then that's your time frame. And the gun is moving, the time is moving, there's things you have to do, and you're just stuck like on that schedule. In state court, it's a little different. Things have changed a little bit more since the pandemic. After the pandemic, there was a backlog of cases because there just wasn't jury trials during the pandemic. And so now state court judges are starting to issue scheduling orders, and they're forcing you to try and litigate, get these cases done. Or if you're not going to get them done, then let's just go to trial. Uh, but still, it's a lot easier to get extensions than state court. The deadlines are a lot less strict. In federal court, you've got judges who are appointed for life, and the dockets in federal court are a lot smaller and a lot more
Mm-hmm.
streamlined. Like you're going to be stuck with whatever the federal judge is going to give you. State court, again, it's a little bit different. You can get away with a lot more in state court, and then the time frames are going to be typically a lot bigger in state court. You can have a case pending. I mean, I've had cases pending in state court for like 4 or 5 years, and you're just not getting to trial.
Wow. Yeah, I was going to ask you about that. So how do you decide whether to pursue a settlement or go to trial? I mean, I'm assuming most of your
So
clients don't want to go to trial.
Yeah, I mean, most people in general, whether you're like a person or a big company, like no one likes to go to trial. If you go to trial, like everything's going to be out there.
Hmm.
If you're like my clients who are mostly out of state, you've got to be away from your families. You've got to go to wherever the case is. You might be gone for an extended period of time. Like I've had cases that I've teed them up for a 2-week jury trial. Typically, especially like me, because I'm lucky I litigated in federal court, the
Hmm.
process is very streamlined. Like most federal court cases are timed to go to trial within 2 years, probably more on the 18-month line. And that 18 months, it goes by very fast, and you can be very busy with a file over 18 months.
Hmm.
So I mean, typically, like what happens is, at least in federal court, is you would start your discovery, you go through the discovery phase, and then you'll have a deadline. Discovery is going to end on this day, and then
Right.
the discovery deadline will end, and then you have to put the results of your discovery. You've got to have everything outlined. You've got have to know where you want to go from there, because everything that you're conducting in discovery could potentially be used at trial. And so, you have to know what's going on based on the results of discovery, what people are saying at deposition, what documents you have, what answers to interrogatories you have. You have to know all that. And for us on the defense side, we typically write what's called a motion for summary judgment. That's one of our pretrial motions. It's one of our favorite pretrial motions,
Okay.
because we're going to say, this is all the discovery we took. These are the facts. This is the law. And this is why judgment should be granted in our favor. And you put that before a judge, and the judge is going to have to say, like, oh yeah, these facts, they're the facts, you can't argue over them, this is how the law is going to apply. And either I'll win at summary judgment, or I'll lose. And if we lose at summary judgment, then we'll go to trial. But all that takes a very long time. And typically, like when I write a very good motion for summary judgment, I can kind of guess what the results are going to be. And that puts a lot of pressure on the other side, because they have to write stuff in response, because we have hard deadlines. You get a motion for summary judgment. Typically, they don't have 2 weeks to respond. And you wouldn't believe how many cases settle in those 2 weeks.
Oh,
Just because it's so time consuming and difficult to write a response to a well-written motion for summary judgment. But yeah, it's just a matter of going through everything, completing all the discovery, which again could take years, and putting it all together in a motion for summary judgment, or a Dauber motion, which can get rid of experts, and putting all that before a judge, and seeing what happens.
okay. I want to ask you: Is it would it be okay? Is it okay if you could share sort of almost like maybe a personal story and how you navigated the situation?
I mean, it's difficult, right? Because I mean, you can kind of look me up on Westlaw, would be like the best thing. I mean, you
Okay.
just wouldn't believe like the stuff you get. I mean, I can tell you like the best thing, at least from like a civil litigator, because it's like, all right, so if you're a plaintiff, right, you're
Hmm.
advocating for the person you represent, so you're always going to be biased in favor of that person.
Okay.
It's the same thing for like what I do, because obviously like I have to zealously represent my client. So it's like, okay, it's what they're saying versus what we're saying. And a lot of like what we're going to do is, I'm curious as to what the neutral people say, because
Hmm.
you're going to get like the most honest, like green testimony from people who have no idea what's going on. And you wouldn't believe how many times I subpoena someone for a deposition, and then the first thing they'll ask, you show up on camera like this, and then you ask them, like, I bet you don't know why you're here.
Right.
They'll be
And
like,
he,
I have no
I
idea.
don't do it. Not at all.
Like, okay, that's great, because that's probably going to support my client's position, because usually I'm dealing with what's being alleged to be very large events. And then,
Hmm.
you take a deposition of, let's say, a tenant, and they're like, I have no idea what you're talking about. It's like, okay, well, your windows, like, how are your windows doing? It's like, I'm looking at the window right now. It looks fine. Okay, well, they're saying your windows have been damaged for like the last couple of years. It's like, I don't know anything about that. And so you just wouldn't believe like the honesty you get from people who have no idea what's going on, as opposed to like cases where it's just like what my people are saying versus what their people are saying. You start going after the neutral people, and you then again, you never know what's going to happen. You could get to the neutral people, and they say, yeah, there's this massive event, and I don't know, I know what's going on. I don't know why things haven't been fixed. I haven't had that situation yet, but I could walk into that. And if I get something where it's that, then, I can write recommendations to my client, and they can decide what to do with it. But yeah, the third party discovery is great, because I mean, I had a case where, you know, it was a landlord case, was alleging a lot of property damage, and I wound up deposing a tenant who was a baker, and this was right after the pandemic,
Mm-hmm.
and they were claiming, like, let's say, you know, $50,000 worth of damage to the tenant space, which was a bakery. And I was deposing the baker while she was sitting there baking, like in the middle of her tenant space.
Mm-hmm.
I remember just like asking her questions, right? Like, okay, well, you know, is there any problems with your paint? And she's sitting there like baking, like you could actually see her baking. And she would just look and she'd look up and like look around, and she was actually there. Like, you know, they're claiming all this damage to the spot, but she's actually there, like doing her job.
Right.
You just be like, yeah, there's nothing wrong. And it's like, oh, well, I can't wait, you know, that I could put that before a jury. Like you,
Oh, okay. So what do you consider some of the biggest ethical consideration for civil litigators?
I mean, facts, right? Like, it's difficult because, like, when you're a defense lawyer like me, like the facts are very important to me, because, you know, facts are the things that I can write my client and explain. This is what happened. This is why you should pay, or this is why you shouldn't pay.
Mm-hmm.
Then on the other hand, then you get the lawyers who all they're concerned about is money, and you know, that's something that's very difficult. Like, you know, facts kind of get thrown out the window.
Right.
As for me, where I want to keep everything like to the facts.
Okay. So how do you deal? How do you stay so professional and maintain your professionalism with dealing with like opposing counsel and everything? How do you just keep that whole professional? Because I'm sure every day it's not a smooth trend, easy day as a civilian litigator, as you said.
I
So.
mean, I would say it's one of those things where you start seeing like the same lawyers like over and over again. Like you'll hear this when you go to law school, that the legal profession isn't very big.
Mm-hmm.
So, you know, like most lawyers know that they're going to see you again. And so all of us strive to have a good relationship. And I can say, like, I'd probably say at least like 95% of the lawyers that I deal with on the other side are just trying to do the best for their clients.
Right.
So it's very easy to say professional. And then, you know, at the end of the day, like, at least for me, you know, it's a job, right? You know, I can go home, I can go to bed, and, you know, I wake up in the morning, and, you know, at the end of the day, like it's more or less like a job. But yeah, you know, it gets difficult. Then, I mean, one of the nice things about like what happens these days with lawyers is emails are just like incredibly important. And so,
Okay.
you know, if you get a nasty email, like don't respond to it. Like, wait, like, you know, go home. You know, there's nothing's going to, you're not going to have an emergency in an hour. You're not going to have an emergency in 5 minutes. Like, sleep on it.
Right.
Maybe if, you know, again, being a defense lawyer, like, I don't, you know, you don't send those types of emails. You get them sometimes. And then, you know, what happens is, you know, you sleep on it, and yeah. I've had lawyers like call me and apologize before because they had sent like nasty emails like, oh, I wish you didn't send that one.
Right. So what are some of the biggest trends you see that's shaping the future of civil litigation? Like you, as you mentioned earlier, you haven't actually been inside of a courtroom for since the pandemic, the last 3 or 4 years. And so, and how is that
I
affecting the way civil cases are handled? I mean, I
so
know.
Yeah, it's cheaper, right? So, like, you know, before, for instance, like, you typically go to wherever the person that you're going to depose is located, or, you know, you have a case pending in Miami-Dade. You've got to fly there, right? Or drive there. And
Mhm.
so, you know, there's costs associated with that, right? So I've got to hop on a plane. That's expensive. I'm going to have to eat. I'm going to bill all my time, you know, the time I get on the plane, go to whatever courthouse. You're staying in hotels potentially. You might have things in one county one day, like, you know, you could have a case in Miami, and then you could have a case in Fort Lauderdale, and then you could have a case in Pensacola, and it's like it's just so much travel. But now it's super cheap because now it's like I can just get on a call like this, and I can have a hearing just like this. So it's gone a lot cheaper. Same thing for depositions. They're taking over video like this. You
Mhm.
do have like the lawyers who say they still want to do things in person because there are things that are lost when you're doing something over video like this. I prefer to just do it over video like this, but there are people who do it in person. Mediations, for instance, mediations used to be like a big thing where you've got to go to wherever the mediation's being held. So, let's say I have a mediation in Miami and I have to fly there. Not just me, my client would have to fly there too, right? Because when you're dealing with corporate clients, they could be located anywhere. And then, the plaintiff, wherever they're located, they would have to go. And it's a lot more time consuming. It's a lot more expensive. So those parts have definitely gotten cheaper and more efficient. And so that's all been a positive. As far as like developments in the law, like that's something that it depends like what type of law you're practicing.
Mm-hmm.
My practice, which is first party property, you hear about property insurance issues in Florida. Those have been changing. Like every year we seem to get like a new bill of our legislator trying to fix the issues with Florida's property insurance. If you're a homeowner, you're probably complaining about how expensive it is. Yeah.
We've had this conversation.
Yeah, so part of that is just because of how expensive and how litigious property insurance is in Florida. We had one-way attorney's fees, which meant as most basic level, if you can get $1 from the insurance company at trial, you would get all your attorney's fees. And so there's an incentive for plaintiffs' lawyers to litigate cases that were generally meritless or only had like a de minimis amount of merit, where they could potentially get like a small amount of trial, just knowing they can churn their attorney's fees, and that kind of made it more expensive on all of us. But there's been pushback to that, and at least in Florida, the legislator's been amending it, and then every year we've been getting like what we would consider to be positive changes.
Oh yeah, because I wanted to talk to you about that. Also, you mentioned I wanted to talk to you about billing for the active the audience and the listener up there. Could you go into detail and actually explain to us like what does it mean by actual billing hours as far as the the client?
I mean, it's billing it's something that takes a while to learn, especially like when you're a defense lawyer. So there's two ways that lawyers are paid. This is just generally. One is on contingency, which you'll see the commercials where it's like, we don't get paid unless you win, and
Right.
It's like you're not going to take the case and then you're going to settle it and take a contingency. So lawyers who work on contingency might not keep track of their hours. I think you really should, because at some point someone may ask to see that. But that would just mean, let's say you're on a 33% contingency, basic, you settle a case for, let's say $15,000, you're looking at $3,000, right? That's $5,000. It's a third. Okay. Right. When you're billing, and then again, that's a plaintiff's lawyer who's recovering money. If you're on the defense side, then you're typically billing your client hourly. So, you do an hour's worth of work and then you bill an hour, and you keep track of everything contemporaneously. And, you're just constantly thinking, and at least when you're at most law firms, you're billing in 0.1 intervals. So, you write an email, like that could be, let's say, a 0.1, or, you could write, opinion letter could take all day. That could be 8 hours. And answering affirmative defenses, that could take half a day. Reviewing a complicated case could take days. You could have 100,000 pages that you have to take a look at. But yeah, it's just a matter of, at least if you're representing corporate clients, they'll have guidelines that explain, these are acceptable billable entries. This is how much time you're allowed to spend on these tasks. And, those are the type of things that you're looking for. It's very important because if you're like me, like, how does my law firm get paid? We're getting paid hourly.
Okay, I was going to ask you about this. So any and every detail that's pertaining to the case, whether it's answering a phone call, sending an email, responding to anything, going over facts, you consider all that part as I'm assuming part is billable. And
typically, typically that's billable. So emails to the client, like, I mean, a client calls you, they're asking you about the case. That's all billable, yeah. And now there are, and again, this is when you're working at a firm like mine, which is just all pure billable hours. A lot of people who are doing, let's say, like they're doing a contract work with like a mom and pop store where, you're writing contracts, or let's say you're doing like a patent for someone, those type of works, those lawyers might still be billing hourly. And, those, they might say like, we'll answer your emails for free, or we'll take your calls for free. But in a firm, where you're representing this, and it's, they call me and we'll talk, and that's billable time. Absolutely.
Oh, so what advice would you give to someone that didn't actually want to pursue to become an actual lawyer going to courtroom, but to become an expired civil litigator such as yourself?
Yeah, so I mean the two most important things are like it's interesting because in law school you're learning all about the analysis. Like
Right.
they'll tell you something that's called IRAC, issue rule analysis conclusion, IRAC, which is just kind of like how a legal memorandum is prepared. But that's where are the issues, what's the rule, what's the analysis, what's the conclusion. But the facts are just so much more important because the facts of every case are different, and the facts are what I can write to a client and explain to them. And then on top of like the facts, like being a good writer is the most important skill you can have with a lawyer. Easy. It's not how well can you argue before a jury. It's not how well you can argue before a judge. It's how well can you explain everything in writing.
Right.
Just to give you an idea, and then this is federal court practice, which is the bulk
Okay.
of my practice. In federal court, I write something. The other side has 2 weeks to respond. They write something. I have a week after that to write something back, and then the judge can rule at any time. That's it. You don't get a hearing. You don't get to go, let me argue my case in front of the judge. Judge, I need an hour to argue this. That doesn't happen. It's how well can you write? How well can I write? How well can you write? And how well can I write back? Because that's all the judge is going to look at. It's not. It's
Wow.
yeah. That's it. So how
Wow.
well can I explain this in a piece of paper?
Paper. So
Yeah. Same thing.
the
State
next.
court's becoming more and more like that. And again, it depends where you litigate. But a lot of state court judges. I mean, I've had cases in smaller counties where if I'll write something and if the other side doesn't respond, then the judge will just rule because a lot of these lawyers aren't used to writing things, and some of these smaller counties will require you to write something. That's not required anywhere. So, for instance. If you file a motion to dismiss right in state court, there is no requirement that you respond back to a motion to dismiss. And then you can just go to a hearing and then you can say whatever you want to the judge. And all you've got to do is convince the judge, like there's some like little bit. And then, in state court, the motion to dismiss is probably going to get denied. And that's like what most lawyers are used to because that's just kind of how it is in state court. Federal court is completely different. Federal court, like I read a motion to dismiss, you don't respond to that. There's a good chance the judge is just going to grant mine. Like the judge is going to read my stuff, say, okay, it's okay. And then bam, that's it. They'll pull the trigger. It's not like state court where you can just kind of sit on it. But again, like more and more state court judges are, reviewing like things that are actually submitted and making a decision based on the written stuff. Because again, that's the most important skill. It's not how well can you take a deposition. That's not it.
And do you think that's fair? Or within the legal system, just to submit, you submit your paper, I submit mine. Judge reads it. Okay, like the way Justin wrote his ruling just in favor, without
Absolutely.
seeing, having it go to trial, without seeing both individuals.
If every case was one that was going to go to trial,
Uh
then my case would never get to trial because there's just so many lawsuits where if the judges were just letting everything go to trial or potentially go to trial, like if nothing was resolved with, for instance, like you can have, let's say something like, for instance, the statute of limitations, right? Let's say a statute of limitations is 5 years and they sue my client and it's year 6, right? Could you imagine having to sit with the case for 2 years, go through all of the discovery, and then go to trial, right? So you've wasted 2 years. Everyone's incurred, hundreds of thousands of dollars in legal fees to get to trial, just for the single issue. Does the statute of limitations apply? And the judge can apply that with a pen. They don't need to have a jury say because it's clear as day. And
Right.
so absolutely, like those cases where the issues are clear like that, absolutely can be ruled without having to go to a jury. And then if you don't like the way the ruling is, there's avenues. Like the case doesn't have to die there.
Okay.
So let's say I win a motion to dismiss. You have every right to appeal that. And then that can go up and then, it would get revealed in state court. It would be reviewed by one of the district court of appeals. And then a DCA will have their say. And, the DCA can affirm it. They can remand it back down. They can reverse it. They can, keep it in part, reverse it in part, all sorts of different things. But it doesn't have to die at the trial level. It can, some of these things really do take a mind of their own where, these cases can be around for 10 years. And, we can accrue hundreds and hundreds of $1,000s in attorney's fees through the full lifespan of a file.
Okay, I have one point. I have has it has it has everything to do with the law. So this is one of the cases that, well, not that I've been studying for through school, but just one of the cases that I've seen throughout the news, the CNN with the squatter case from up in New York, where the guys um they just end up moving in her house, and they didn't want to leave, and they did it for a while, and they I think they made her. It was a while. It took over a year finally, even before the guy got arrested, but she couldn't do anything. The law wouldn't allow. She got arrested for changing the locks on her door. The cops came and arrested her and told the guy that was squatting in her house, I mean, didn't anything happen to them at the time, but she got arrested for changing locks on her own home that she owns, pay the taxes and everything. And it was at that moment when I said, hey, this isn't fair.
So that's I don't because so like law and politics are inherently intertwined, right? And
Right.
then something like that would be governed by whatever state you're living in, right? Because that would typically like those sorts of issues are seen to be like more of like civil issues, and a lot of that's to protect people who are like legitimately living in these places. It's not to protect people who are illegitimately living in these places, but you still have to go through the same process.
Hmm.
And I don't know the facts of like that particular case. A lot of it could be the legal process is complicated. I don't know if they have lawyers involved. I don't know how backed up some of these judges are.
Right.
But I would say like just general like advice, like don't do self-help, because if you do self help, then you can be in trouble. Always, if you have like something like that, like always consult a lawyer who specializes in that area of law. That way, they can lead you through it. Because yeah, if you do something that's self help, you're probably going to get in trouble. That's
Okay.
something you'll learn in law school. That'll be literally the quote, like no self help. Like if you're trying to do something because you're just going to help yourself because you're upset, like don't do that. There's better ways to do it. Um,
Oh, okay, Justin. So it's time for rapid fire questions. I'm gonna ask you a couple of questions before we get a few questions. All right. One of my what is the most overrated legal movie scene to you?
Oh man, I'm probably my cousin Vinny, right? You just have like those drop the mic moments in the movies, and then that doesn't happen in real life. Although I had one that was close. That's a conversation for another day.
Okay. What is one book every lawyer should read beside the legal text?
Hmm. Stay away from. There's the famous guy who writes all the fiction books about lawyers. Who is a lawyer? He wrote a book called The Firm that I read when I was younger. Um, Man, that's gonna bother me that I can't remember his name. I'm just gonna Google it real fast. Let's see the
Okay, it's fine.
firm. It's John Grissom, but
I, I heard of him.
yeah, I mean, so he's the fiction writer for, but keep in mind, like his stuff, it's entirely fiction. It's not how the actual practice of law is. Um, so yeah, that's one book. I'm trying to think of. I mean, obviously, like in law school, you're gonna be reading all of your textbooks.
Hmm.
I can't say I've opened my textbook since graduating. That's terrible.
Okay, and the last question. Mostly, if you weren't a lawyer, what would you be?
So something that's interesting is when you're a lawyer, you're not just working with like yourself, right? You're working with all sorts of other professionals. So I have had the pleasure of working with engineers, people who are really good at estimating things, really know the construction industry. I've had the pleasure of working with accountants, and so that's what I would do. These accountants, man,
Hmm.
like the way these accountants know their way around Excel is incredible. And if I was to go back, yeah, then yeah, I would consider being an accountant, which is another boring job where it's kind of just like a day job. Um, but yeah, it's the consultants who work for like an insurance company or they're involved with these sort of stuff are just incredible. Whether that be an accountant or an engineer, like those are great jobs.
Oh, okay, well, Justin, thank you so much for stopping by and talking to us about the day in the life of a civilian litigator. Appreciate you so much. as always. And I hope the audience got so much from just sitting listening what a litigator goes through the day in day life. So if you do decide, people, if you ever want to get into law, please check out the episode, like and subscribe. And once again, Justin, thank you so much for stopping by.
Yep. Thank you for having me.
All right, thank you. Take care, my friend.